Hi, I'm Greg Dell, joined by attorney Frank Darras, and we're going to talk about damages in bad faith long-term disability insurance claims. And Frank, we've done videos talking about what bad faith is in a long-term disability claim, and we have not really spoken about if you're able to prove bad faith, which we've talked about what's involved to do all that, which is a giant hurdle. You finally get to the why are we even doing all of this? What can a claimant obtain if they prevail on a bad faith claim? So can you talk about what the available damages are for somebody who is able to prevail in a bad faith long-term disability claim?
So if you've got a policy and you live in a state where bad faith and punishment damages are available to you, you not only get your contract benefits, your monthly disability benefit, because remember, you paid a rich premium to get a monthly disability benefit if you weren't able to do your work. So when an insurance company unreasonably or without proper cause delays or denies your benefits, there's consequences for that. Why? Because how's the insured going to pay for his medical treatment? How's the insured going to pay for his prescription medication? How are we going to get the tests that we need? And most of the time, all of our insureds have obligations. They've got a mortgage. They got kids. They need to put gas in the car. They need to put food on the table. And when your kids go without, when your car gets repossessed, when you lose your home to foreclosure because your insurance company didn't do the right thing, those are extra damages that the insured is certainly entitled to, as well as attorney fees. You know, why should you have to pay a lawyer for the work that they did when the insurance company had plenty of information? They had all the good stuff to be able to pay you timely. Now you've got to go give up a percentage of your benefits to your lawyer. So, consequential damages. Anything extra. You got delayed, you got credit card interest, you got mortgage foreclosure, or you got behind, your credit stained. You know, remember, Greg, credit stains can last 10 years. It's like a ball and chain on my insureds. So we can get the interest on the lost or the delayed benefits, our disability benefits. We can get all our consequential damages. Anything that was caused by the insurance company's delay or denial. And then sometimes I have wealthy clients who can afford the premiums. And just because the insurance company didn't pay them timely, they're wealthy. They're millionaires. Or, you know, I do a lot of sports. They're billionaires. Okay. In those circumstances, is the insured going to be upset and have emotional distress damages like my regular insureds? They should be distressed. They paid a premium. They got cheated. They got delayed. But my millionaires have too much money in the bank. The insurance company says, oh, come on, Frank. Why is your guy upset about that? You know why? Because you made a promise to pay him if he or she was unable to do their work. So we can still get the attorney fees and we can get punishment damages. Because a lot of times, Greg, if the case is worked up properly, we can show it was evil, it was vile, and it was loathsome. And the average juror is going to look down upon that conduct. And that's when you get punishment damages, a percentage of the insurance company's net worth, as a reminder to them. Don't you dare cheat a poor insured. And
Yeah.
worse yet, don't cheat the wealthy ones.
I wanted to talk to you about that because a lot of people hear, oh, this insurance company, $50 million, $80 million, $20 million, $5 million in bad faith punitive damages. What are punitive damages? Where does that money come from? Who gets that money? I mean,
it's a separate damage element in our bad faith cases that involve disability. So first is the disability contract. Second is emotional distress, consequential damages if you got behind on your mortgage, car got repossessed, didn't have the money, had to go borrow it on your credit cards. And the distress, the worry, the chagrin of being cheated and facing your family at the kitchen table. Gee, Dad, you paid all that money for those premiums. Insurance company's not paying us. That's wrong. That's emotional distress. Your lawyer's fees. Punitive damages, different. That is a separate hill to climb. You have to prove by clear and convincing evidence that the insurance company acted evil, vile, loathsome, and despicably. Then we look at the insurance company's net worth. How am I going to get an insurance company's attention? They're a billion-dollar corporation. What if I gave them a fine of $100,000? Nothing. How about $1 million? Nothing. These are 100, 200, 500 billion-dollar insurance companies. They need something that stings, something that's going to change the conduct. And a punitive damage verdict sobers up the insurance company. And it's the great equalizer where an insured who's been wrongfully denied their benefits, they've suffered emotional distress, they had to hire a lawyer, they lost their house and their car and a refrigerator got repossessed. Now we come back and we say to the insurance company, don't you ever do that again. And if you do, we're going to use that punitive damage verdict that Greg and Frank got in Florida. We're going to hold it up in front of the jury to show them they didn't get the message. They got punished, but they didn't get the message.
So my question to you is, you've thousands of bad faith claims you've investigated, been involved with. How much fear does a disability insurance company have of a potential punitive damage verdict against them?
It all depends on how the claim was worked. So if you don't have the money or the war chest to be able to take all the depositions that you need to be able to prove the conduct was unreasonable or without proper cause, if you don't have great doctors, and when I say great doctors, I want the chair of the Department of Orthopedics in downtown Los Angeles at USC Medical Center or Cedars-Sinai or here in Florida. I want the top doctors. I want the best vocational people. I want the best video depositions of all the claims people. So the jury gets a picture of this company and how they cheated and lowballed and delayed until they could get the denial letter and steal the money from the insured.
But when you're filing these complaints and for bad faith, and the bad faith cases are limited. It's not every case we put in, and because they are so detailed, so involved, so expensive to pursue, we pick and choose the ones that we truly believe this is a bad faith claim. The big insurance companies that we've gone against many times, how fearful do you believe they are when they see our name on there and they know we're coming for them?
The last thing an insurance company wants to see is our name on a complaint. Why? Because we framed the claim. We know how to prove bad faith. We know how to show a jury what's unreasonable. So it really comes home. We've got the depositions. We've got the evidence. We try and look at the institutional practice. What did they do to create these hurdles to prevent the insured from getting paid timely? And then we can put the punitive damage claim around the bad faith claim. And for an insurance company that looks at us and says, oh great, it's Frank and Greg coming back for a bad faith case. Gosh darn it, those guys are going to spend $150,000. They're going to have 15 depositions of our company personnel on videotape so that if we find a practice that's unreasonable, we're going to. It's not that hard. You know, at deposition, I ask a claim manager, sir, what prevented you from spending as much time as you thought would be necessary to look at this claim with an eye towards payment? What prevented you from investigating whether my insured's doctors were more trained than your doctors? What prevented you from reprimanding the claim person here for what they did or they didn't do? You know, we've got guidelines, we've got policy, we've got procedure. State by state by state, it's different. So if I go back to the home office in Massachusetts on a California claim, I know that I've got these guidelines that they needed to follow. And I've got the wherewithal, the experience, the know-how to be able to frame that punitive damage claim. And you bet they're nervous because we've been behind hundreds of millions of dollars in extra contractual and punitive damage claims.
And claimants call and they say, Greg, you know, this company did $1 billion in profit last year. Do they really care that you're going to potentially get a verdict out of them for $5 million, $25 million, or $50 million? And I say to them, especially with the publicly traded ones, I say, you bet they do, because that affects their profitability, it affects their stock market price, and even more so, bigger picture, and I always try to remind the insurance companies of this, but they don't get it. It affects their ability to sell policies in the future.
I think it's such a good point you raise, because things are different today than they were 3 years ago. You know, before COVID, insurance companies had salespeople out on the street, agents, brokers. They sold policies. They had all the bells and whistles to be able to entice an insured to buy a disability policy to protect their family and their financial future. COVID came. What happened? No salesmen on the street or saleswomen on the street. The brokers weren't selling disability because people weren't working. The disability industry was disabled. So I look back and say 3 years ago, at the beginning of COVID, this is a different landscape. Insurance companies now, they are inspecting, and I mentioned earlier, taking the salt out of the pepper. They examine the initial claim packet. They are looking at every single way that they can buy more time, that they can create a genuine dispute. Because if an insurance company can say, oh, Frank, you got an orthopedist? We have an orthopedist. We got a medical dispute. Oh, gee, Frank, you got a CPA? We got a CPA. That's a financial dispute. Oh, gee, Frank, you got a vocational guy? We got a vocational guy. That's a genuine dispute. Genuine disputes, Greg, don't make a bad faith claim. When you're building a bad faith claim, you can't have a genuine dispute. You better be terrific in terms of the depositions you're taking and the evidence that you're gathering. And oftentimes, I'll come back off a road trip like that and say, I learned so much. It may not affect this claim, but I have 600 cases or 300 cases. I can use that information to help another insured without having to take 28 depositions in that particular case. So it's so good that you get out there. Oftentimes, I'm there every other weekend or week. I may not see another plaintiff lawyer the whole year, which is shocking to me that people are touting bad faith, but they're not going to the home office. They're not spending the money. It's important.
Yeah, it's really important to be able to know how to do these cases and put them forward and know that the insurance company knows that they have a formidable enemy against them who is going to do everything possible to pursue the claim. But this was a good, introduction to the damages in a bad faith, talking about the compensatory, the emotional distress, and then at the end, the punitive, which plus attorney's fees. I mean, there's a lot of components to it, and in many states it's done differently. Sometimes the damages is a separate stage. You first have to prove the bad faith, and then you come back and then prove the damages. Or in some, you prove them all at the same time, and you're there saying, this is $1 billion company, and they did wrong, and we want you to punish them, hence the word punitive. So people shouldn't think this happens in every case. And really, fortunately for claimants, it doesn't happen a lot, because otherwise everybody would be getting denied their claims. But when it happens, it's a horrible thing for the claimant. And I know we take great joy in representing that claimant, because they often feel, how am I going to go up against these multi-billion-dollar entities? And they are monsters, and they do have lawyers, and they have lots of people. But as you and I know, they're not as big as they seem, and I find that they have very weak support system, and once you get in there, it's easy to take them down if you know what you're doing.
I never saw an insurance fight I didn't like, and I always knew I could make a difference. One lawyer, one law firm can bring down bad faith, unreasonable conduct, cause punitive damages. When you get a punitive damage verdict against an insurance company, things change. They have a change of the guard. They're going to lose their vice president of claims. They're going to change their in-house people, lawyers, who evaluated the claim. And you get punitive damages against an insurance company for this evidence, It helps everybody.
It's
But not everybody can do it.
Right, it's a great point. So if you're someone out there who has a private long-term disability insurance claim and you believe you've been wrongfully denied, feel free to reach out to Frank, myself, any of our disability lawyers. No matter where you live in the country, we're available to assist you, and we'll always provide you with a free consultation.